Welcome everyone to BMI's virtual education platform. Today's webinar is hosted by chapter sponsors: Nature Zone Pest Control, Parking Lot Services, CPR Concrete Painting and Restoration, Appleton Reiss, ACP LM, PPG Paints, Mitchell Insurance Services, Yellowstone Landscaping, LRE Ground Services, Delta Engineering, Fieldstone Landscape, BB&T Association Services, Down to Earth Landscaping, Reynolds Painting Group, PCS Insurance Group, Florida Paints, Centennial Bank, and Crown Roofing.
While we allow everyone time to adjust their Zoom settings, we have just a few items to announce. This may be the first BMI event for many of you. Our organization was established by community managers for education resources. We focus on providing a comfortable environment for managers to learn while also introducing CAMs to ethical service providers who specialize in the industry. Today we are presenting a 1-hour accredited online course. For those of you who would like to receive a credit for this course, please listen carefully. If you have registered on the BMI website and received the link directly from us, you are all set. However, if someone shared the link with you and you have not registered your attendance with BMI, please go to our website at bmitampa.org. Again, that's bmitampa.org, and do so before the end of the day. We are only allowing a course credit for those who registered on the BMI website and who are in attendance during the full webinar. After the webinar, you will receive an email from BMI with a link to an online rating and review form for this course. Please make sure you complete this. Many of you may be registered on Zoom with a different username than your actual name, and this assists us in making sure we check you in for attending the class. Questions will be addressed via the chat as time permits, and those not answered during the webinar will receive an email answer from our course presenter within 48 hours. So please make sure you utilize the chat for any questions you may have. Again, thank you to our sponsors for supporting manager education with BMI Tampa. We want to remind you of our summer virtual raffles going on. You can visit our website or LinkedIn and Facebook pages to find out more information, or you can email us. We are raffling off e-gift cards weekly. Please make sure you check our website regularly because we are updating our webinar schedule weekly through mid-September.
And with that, I would like to introduce Ms. Nicki Asmer of Appleton Reiss, who will be presenting our course today.
Good morning, everybody. I am very happy to be here today. I'm on vacation in Santa Rosa Beach, but I absolutely wanted to take the opportunity to do this course for our community association managers. A little bit about myself. My name's Nicki Asmer, and I'm an attorney in Tampa Bay with the law firm of Appleton Reiss, and I have been practicing in the community association realm for approximately 20 years. Prior to being with Appleton Reiss, I was with FL Legal Group, and prior to that, I had my own practice for about 16 years, also focusing on community association law. We represent condominium, HOAs, and co-ops throughout the state of Florida. We also represent at the beginning stages from developer and transitioning to the association. So we have combined experience of about 40 or plus years. So I'm really happy to be here, and I'm glad that you guys took the time to join us today. And if you would please, as Carrie had indicated, use the chat for questions, and then during some sort of break during the slides, Carrie will let me know what questions we do have and I can address them. So let's get started. So we're going to be talking about emotional support animals, and unfortunately we are losing this fight. And when I say we, I mean all of the community associations at issue with this problem. There are a lot of individuals who are trying to manipulate the system, and I think everybody has had their own experience with this. You know, somebody brings a dog into a no pet community and they say, oh, I need him for an emotion or support animal, and they hand you some bogus certificate that they purchased online. So I'm very familiar with a lot of those schemes that homeowners try to pull. Thankfully, there was legislation that passed this year, and it's effective on July 1st to help combat some of those issues. So we'll be talking about those laws at the end of the course and some of the current laws that you guys need to be aware of as far as community association management is concerned. So support animals and emotional support animals, there are differences, and I want everyone to understand what the difference is. This is a very highly contested and diverse issue, mostly faced by condominium associations because of the structure of the building. Right now, there are about 1,500 arbitration orders in Florida regarding the keeping of pets in a condominium association. Now, one of the things that some of the board members confuse with this regulation is that if you have a no pet zone or a no pet building, that you can't have any type of emotional support animals. So that is not the case. And I want to make sure that everyone understands that an emotional support animal or a service animal is not the same as a pet. They are not pets, and they're not considered pets. Under the American with Disability Act, which is the main statute federally that we focus on, and there also is a Florida statute regarding the Americans with Disability Act. This is when you're going to be getting into the service animals, because they are specially trained and they are permitted to be in public places and may protect other service animals in housing. So under Florida law and also the federal American with Disabilities Act, as long as a person has a disability, they can bring their service animal to all public accommodations. And we're talking restaurants, museums, hotels, stores, and we'll get into a list of what the public accommodations is in the next slide. So the Florida law versus the federal law. In Florida, and the ADA differs in some ways, but it's mostly the same. Public accommodations in Florida must comply with both sets of laws. And the person who is entitled to use those restrictions or rely upon them can use either one of those statutes for enforceability. So what are public accommodations? Kind of think of it where you need assistance to get to and from somewhere or to gain access to someplace in a public setting. For example, hotels and other lodging establishments, public transportation, terminals, depots and stations, restaurants, sales and rental establishments, any place of public gathering, such as an auditorium or a convention center. Again, libraries, museums, recreational facilities, zoos, parks, and educational institutions. So the Federal Housing Act is a bit different when you compare it to the ADA. This actually gives individuals greater protection against discrimination. And it requires that a person to have a handicap defined in the statute as a physical or mental impairment which substantially limits one or more of such person's major life activities. And when we talk about major life activities, we're talking about dressing yourself in the morning, brushing your teeth, just trying to do things and in a normal setting, but because of some physical or mental impairment, you are unable to do those things. Next, the person must demonstrate that the requested accommodation affirmatively enhances the disabled person's quality of life by ameliorating the effects of the disability. So what does that animal do to decrease or assist the person with the disability? Is it a service dog that reminds the person to take medication? Is it a type of disability where someone is having a seizure and the dog can actually interpret or foresee those type of seizures because there's a chemical imbalance that happens within a person that only the dog is able to trigger and remind the person? And then finally, we look at the requested accommodation. It has to be reasonable, okay? So we're not talking about someone who needs an emotional support animal and they're living in a condominium association, then they want to bring a horse onto the property. That's not reasonable. There was also another case involved regarding a parrot, and this homeowner wanted to bring the parrot to the pool. The problem is that the parrot was actually attacking the other homeowners that were using the pool facilities, and the court had determined that this was not a reasonable accommodation. So remember, when you're looking at somebody's request, is the accommodation reasonable? If you're just in a no pet community and you have someone who wants to bring an animal into the community for some sort of a disability that they have, then it would be a reasonable accommodation for you to allow either a dog or a cat, even a snake, as long as the animal was under the control of the homeowner.
Nicki,
Yes.
Keith has a question. He said that he's actually in a community that does not allow pets, but many are getting ESA letters. And you may have touched on this a little bit, but his question is there anything the board can do to limit the amount of animals? Well, this is a three-part question, so I'll stop there and ask the next two when you get done with that one.
Unfortunately, we cannot do anything to limit the number of animals because the Federal Housing Act and the Americans with Disability Act is specific to individuals. So if you're talking about putting a cap on the number of animals that can come in, that wouldn't be enforceable, and you could possibly find yourself in a lawsuit. What was the second part of that question, Carrie?
What does the association do with people who are allergic to animals?
Allergic is also another issue. Some people have actually taken the flip side coin of this argument, saying, well, you need the dog for a disability, but what about my rights and being allergic to animals? That, again, we go back to, is it a reasonable accommodation? And unfortunately, those people that have allergies don't have the standing that a person with a disability does, as far as having an animal to help them enumerate those type of disabilities that they're faced with, and the animal actually assists them with those disabilities. So unfortunately, those people with allergies just need to stay away from the dog if they're out in the common areas of the association. Is that the other question, Carrie?
Yes, I think he was trying to say, how do you accommodate everyone, but you pretty much just answered that.
You can't accommodate everybody, unfortunately. Just like my father and my grandfather taught me, you can't make everybody happy, so do your best and hope for the best. But as far as these laws are concerned, there has to be a line divided between the disabled person and the reasonable accommodation, whether or not what they're requesting is actually reasonable. Okay? So next, the person has to demonstrate that the requested accommodation affirmatively enhances a disabled plaintiff's or person's quality of life by enumerating the effect of the disability, okay? Elements necessary for reasonable accommodations in Florida condominiums, excuse me. What is the disability for the purpose of entitling a reasonable accommodation? What is a major life activity, and what is an impairment? So these are all important questions when you're evaluating an application for someone who wants to bring in an animal to a community that has a no pet rule. So what is the difference between the FHA, which is the Fair Housing Act, and the American with Disability Acts? So unlike the ADA, there are no specific training and do work requirements for animals in the FHA statute or regulations. remember, when you're talking about a service animal, this is an animal that has actually been trained to help an individual with their disability. That is under the ADA. The FHA does not require those type of trainings or type of activities that the dog or the other animal is expected to know how to do to assist this person. In addition to dogs and cats, cases brought under the Fair Housing Act have recognized other animals as providing emotional support for a person suffering from an emotional disorder. And that would be, and I've had cases where we've seen some strange animals. I had a huge snake, and the lady wanted to bring her snake to the board meetings, and we're talking a humongous snake. And we had advised her that in order for her to bring the snake, she would have to keep it in a cage with her. She used to come to the meetings with this huge boa constrictor wrapped around her neck and used to freak everybody out at the board meetings. So if we tailored some of the restrictions for the type of animal as well, you could do that. But just be very careful. I've also seen some guinea pigs or some other odd animals, iguanas, or I even had a dragon one time that came in. They look a little bit like an iguana, but they're actually considered a dragon. So, you know, we had to make the accommodation, but of course you have to have some parameters, reasonable parameters around it, because it can't be a safety issue to the rest of the community. So whether the accommodation request is reasonable can also be a difficult judgment. So when you're in doubt, please send an email to your attorney to see whether or not they would consider this a reasonable accommodation under the circumstances. Under the ADA, other mitigating solutions that might be available, such as taking medication, may not be considered in making that determination. So if we have a community where it is in a condo building, and let's say the animal is a horse, okay, and this horse is supposed to help this person remember to take their medication, under those circumstances, we wouldn't be considering this a reasonable accommodation, okay? And just because of that factor of that the animal is assisting this person to take the medication, again, it would not be the same circumstances. So again, think of it on a case-by-case basis. And this goes back to the original question that we had, and can we stop the number of animals that come in? And unfortunately, no, we cannot. So here are the issues that community associations are faced with when they are considering allowing an emotional support animal or service animal into the community. You're going to have probably some restrictions in the declaration that indicate that there are no pets allowed. And again, you would need to put in place some reasonable accommodations for the disabled individual to have this animal assist them. Any restrictions on housing, which include maintaining an animal in a condominium, can and often does conflict with the federal laws. So again, when I have board members calling me on the phone and saying, well, we have a person that's trying to bring in a Doberman Pinscher or a pit bull, and we don't allow any pit bulls, or we don't allow any Doberman Pinschers, okay? Even if the restriction on a certain type of breed is contained in the governing documents, a reasonable accommodation would allow it. But you could also produce some things like have the owner sign a waiver that they would be responsible if the pet attacked anyone, or saying that the animal has to wear a face covering or some sort of a muzzle if they are considered to be a dangerous breed. So again, even though the restrictions are in the governing documents, 9 out of 10 times they're going to conflict with the two statutes that we had referenced to earlier in this presentation. Required determinations. So these determinations, whether there is a mental impairment or whether there is an impairment substantially impacts a major life activity, and whether the request support animal is reasonable, call for comparison but also finesse and perception to distinguish those persons who are making a legitimate request versus those who are trying to scam the system simply because they want to keep a pet. So what is a service animal? Florida has its own set of service animal laws, and they apply to animals that are trained to do work or perform tasks for someone with a physical, mental, psychological, or sensory issue. The work the animal does must be directly related to the person's disability. For example, you may have an animal that provides stability and balance to someone with an impaired mobility. It might alert someone who has a hearing impairment to sounds. The phone is ringing or the timer in the oven has gone off, and this animal alerts the deaf person that there is a timer or something that's gone off. Might interpret someone with a psychiatric disability from engaging in self-destructive or dangerous acts. I've also seen another animal who was able to calm a person down when they wanted to inflict harm upon themselves, either by hitting them in the head or doing any other physical type of mutilation or other type of self-destruction to the person, and the animal would be trained to help them relax and calm down so that they can get out of that psychiatric stage or mental state.
We have a question.
Sure.
A community has leasing and pet restrictions, and the tenant's brother, who is not on the lease, is staying long-term overnight with the dogs. The additional overnight tenants and dogs, not on the lease, are being claimed as service dogs, both pit bulls less than a year old. The HOA denied the lease application for misrepresentation. The tenant is claiming discrimination for their dog. No proof of service animal status was supplied either. Can the tenant claim discrimination under FHA or ADA have a merit to this?
I heard that it was a service animal. Is it a service animal or is it an emotional support animal?
Long-term stay overnight, additional tenants. He's being claimed as a service dog, but then down here it says that they've received no paperwork showing that he is a service dog. Is that correct, Denise?
You can unmute yourself, Denise. Go ahead and hit your unmute button, Denise.
Hit it again.
There you go.
Okay.
Go ahead. Give me some more specifics on this scenario so that I could try and answer your question.
I did not answer that question.
Oh, okay.
Sorry.
Well, it was nice talking to you, Denise.
You too.
Who asked that question? Could you unmute yourself, please, so I can give you some more details or get some more details to answer the question?
We had 3 Denises on here, so
Oh, okay.
I don't know which one it was.
Well, let me say this in the short run as far as this situation is concerned. If in fact it is a service animal, that means they are trained, okay? There should be some type of paperwork or a documentation that the homeowner or the tenant or whoever is the handler of the animal would have in their possession to show that it is a trained animal, and that she requires to have the animal. Now, it doesn't matter what the status of the occupancy is, whether it's a guest or a tenant or a friend of a tenant or a family member of the tenant. You still cannot discriminate against this individual for having an animal, especially a service animal, when they are visiting a community that has no pets allowed. And normally what you see, and some people don't do this, is they have the animal with a badge on it that says it is a service animal and that they're working. As far as the emotional support animal under the FHA, that's a little bit different. You know, when they are staying with a family member or a guest and there is an animal, they should produce documentation to the effect that they have a disability and that it is an emotional support animal. But I always err on the side of caution and tell my clients, you know, this is somebody who's only staying for a couple of days. You don't want to rock the cage or wake the beast and find yourself in a lawsuit, a federal lawsuit with the ADA or the FHA in terms of denying this person the ability to have their requested animal on the property for a short period of time. And if this guest ends up staying long-term, then they would have to go through the process of the application, getting a doctor's note, and then I'll be going over that in more detail in this presentation as far as the application is concerned.
Now, on that, what you were just touching on, you may have, just to clarify, so if they're temporary, they should not ask for the paperwork for the ESA, but do they have the right to ask for the paperwork if they're temporary?
Yes, they do. Think about it this way too. Somebody comes into a supermarket and they've got a dog, okay? And the dog is wearing a service animal badge. How many of those Publix employees do you think are going to go up to this woman and tell her that she can't have a dog there? It's the same type of situation, okay? But now we're dealing with federal statutes regarding housing and also disability acts under the ADA. So be very, very, very careful and keep in the back of your mind that this is an area where the associations are not winning, okay? They are having to require reasonable accommodations for animals that are used either for trained purposes or emotional support purposes.
So would you say that the boards should not post something to their residents stating that any visitor with an ESA animal must let the office know beforehand that they're having a person come on with an ESA animal?
I would recommend that, yes. I would recommend that you do that. It should be, if we have a restriction in the declaration for no pets, I would change that. Not to say that you can't have any pets, but only for an exemption to those individuals who have disabilities and they have a trained animal. And listen, guys, I'm a dog lover. I've got dogs. I've had dogs all my life. And if I could take my dog everywhere, I would. But again, at the same purpose, I don't have a disability or an impairment that requires me to take my dog everywhere that I need to go. So think of it that way as far as when you're trying to evaluate these things. The amendment to the declaration would definitely need to provide some exceptions to this rule as far as the emotional support animal. And if you do put that in your declaration or you do not have something in the declaration to that effect, you can implement a rule. Of course, if you have the authority to implement rules in your declaration, for the board to make certain exceptions under the federal statutes.
Thank you.
Okay, so let's keep moving along. Service animals continued. So for public access and accommodations, only service dogs and miniature horses are covered. For housing, this limit does not apply. Other types of animals may be covered. So an emotional support animal is not a pet. If there's anything that you should take out of this class, this is it. Emotional support animals are not pets. So the board cannot reference these ESAs as pets. And an emotional support animal may be a reasonable accommodation. Neither the ADA and Florida laws do not cover pets or emotional support animals. So remember, this is an FHA issue for emotional support animals, okay? And that's what we're dealing with. We're dealing with condo associations and the housing of these pets within a building that doesn't require pets or animals. Owners of public accommodations are not required to allow emotional support animals, only service animals, including psychiatric service dogs. These are animals that provide a sense of safety, companionship, and comfort to those with psychiatric or emotional disabilities or conditions. I know of some veterans who have PTSD that require a service dog or emotional support dog to help them just get through the day, because they offer that veteran some type of comfort for his psychiatric inabilities or mental state. So even though these animals often have therapeutic benefits, they're not individually trained and they perform no specific tasks. They're basically there to comfort the individual or the person who is facing these issues. Under the ADA and Florida law, again, these do not apply to emotional support animals. So here is what we were discussing earlier. What can the associations do? First, request proof of the disability. What I normally do is I have an application process that I have created for my clients, and the application process will go through all of these numbered requirements. And it would be for the physician to fill out and also sign, providing this information. And if anyone needs an application, I can email that to you after the class. If you would please send me an individual email so that I can give you that application process. I think it's a 2-page document. It's fairly simple, and I provide it to a lot of my managers so that they can go through the process of actually determining whether or not this is a scam or it is a legitimate request. So before that, I actually would create this application, the traditional format, and you can use this as well with your associations, is to request a letter from the physician. If the physician is familiar with the language in the statute, they will know what needs to be stated. If it doesn't have the language that the statute requires, I would definitely share this with your attorney and ask them whether or not the application should be rejected or it should be approved. One of the things that needs to be addressed in the letter is the disability, okay? The association cannot and should not ask the member what the diagnosis is, okay? But you can describe and list major life activities impaired by your disability and the impairments. So who determines you to be disabled? You have to provide the full name and qualifications, including the CV of the person who's determined you to be disabled, and a letter from that person. Be wary of the type of letters that you get from non-medical personnel or persons who are trying to pass this off as an emotional support animal, and they're possibly just charging the individual a sum of money to produce this letter, or to just say that they need it to better their lives due to a disability. So describe also whether and how the emotional support animal ameliorates the symptoms of your disability, and that means how they lessen or help improve your life, and the major life activity or activities your emotional support animal allows you to accomplish. So there has to be a correlation between the actual disability and the emotional support animal connection to reducing those issues for the homeowner. If it doesn't have that in the letter or in the application, you can make a fair assumption that it is not to be approved because it does not connect the disability with the acts of the emotional support animal to assist that disabled person. The ESA
Looks like we lost connection, but it may just be you, Nicki. And you're muted. Let me unmute. Hello, unmute. Okay, now you should be able to hit your unmute button. Bear with us, everyone. Gotta love this technology. I think that's back. You're back.
Okay, I'm back. Thank you. Hold on one second. Let me get this up and running again.
And while she does that, I want to let you guys know this is such a hot topic, and I know there's going to be a lot of questions going back and forth. So what we'll do is when she finishes the presentation, I'm just going to unmute every one of you guys, and then we'll just start a chat. And you know, you guys just take your turn asking the questions that you need to ask. Does everybody know how to unmute themselves? Because even though I've unmuted you, you still have to go in and do it yourself on your phone, I believe, or your computer. Send me a
Terry,
chat
can you
message.
hear me?
Yes, I can hear you.
Okay, perfect. All right, we're back. And again, I apologize because I'm on vacation, so the internet is pretty sketchy here. But I wanted to take the time to teach this course today because it is a very hot topic, and I know there's a lot of questions about it from community association managers. So let's keep going. All right, so here is one of the things that the application should state, okay? I understand that the Fair Housing Act defines a handicapped disabled person as one who has either physical or mental impairment with a substantial limit on or more of such person's major life activities. Number two, a record of having such an impairment, or three, being regarded as having such an impairment. I certify that the patient is a handicapped or disabled person pursuant to the above definition from the Fair Housing Act. And then I actually put whether or not it's a yes or no to indicate that you don't have an opinion, and add any additional information that you wish to add. So the reason why I wanted you to see this language up here is because this is the connection that needs to be contained in that letter from the physician. And if it's not in the letter from the physician and you're using an ESA application, the application has the certain buzzwords and the language that is necessary to connect the physical or mental impairment, the disability, with the service animal, okay? So now that the association has been provided with proof, what do? Now you have to keep these records in a separate file from the official records. Remember that none of this that we're discussing today is considered an official record of the association because it deals with a disability, mental, and medical records. So it would be a huge violation if any of this information was shared through records request with another homeowner. Never, ever, ever produce those medical records or otherwise make them available. And again, they're not considered official records of the association and have to be kept confidential. Again, you can create a voluntary application registration, and all of the information that we've discussed here as far as the disability, what it is, and how the animal helps the individual enumerate the disabilities by assisting the homeowner or the tenant or guest or whoever it is. I also create a voluntary waiver. The waiver basically states that the homeowner, if they are permitted a reasonable accommodation for the animal, that they assume all liability of the animal while they are on common elements. So if there's a situation where you have a dog that may be aggressive, that waiver would protect the association from any animal bites in the area. And if this was a dog that had a history of aggressive behavior, then that may be cause to deny the application. So if we know the dog has bitten 3 times, you can say, I'm sorry, but this is a dangerous animal. They've bit people 3 times already, and we can't allow this reasonable, it's not a reasonable accommodation, because you're endangering the health and safety of the individuals in the community by doing that. Some of the other things that you can do without actually amending the declaration, because I'm aware that declarations normally have a very high percentage in order to change the documents, which may prevent the board from allowing these type of restrictions, meaning that all animals have to be kept on a leash. How long is the leash? What are the designated areas that the animal can relieve itself? And things of that nature. So for the ESA, pursuant to an amendment to the declaration, if you cannot do it, or it is complicated because of the amendment procedures, check to see what your bylaw amendment requirement is. And you may be able to put it in the bylaws as a separate section, just so it's in the governing documents. But if the board does have rulemaking authority, meaning there's a provision in the declaration that says the board has the power to implement reasonable rules and regulations regarding the community and the use of the community or common elements, because it may be difficult for you to amend the declaration based on the amendment language. And if anyone has specific questions regarding the governing documents, please email me and I'd be happy to assist you with that as well. Okay, so I'm going to switch screens quickly because I want you guys to read this HUD press release that it passed on January 28th, 2020. It provides a set of best practices regarding the type and amount of documentation a housing provider may ask an individual with a disability to provide and support. And let me just switch screens real quick so that I can show you guys what this HUD release looks like, okay? So when you do the search based on the website that was on the presentation, this is what you're going to see. And it's a little lengthy document, but it's in the form of a question and answer, and it gives you the purpose and who it's applicable to, and if the FHA applies and the ADA applies. But here it is, okay, and it is extremely helpful, and I would recommend that everyone download this and read it. It's 19 pages. So that you have an understanding and a background of what is allowed and what is not permitted as far as requesting information. And it also has some other links, okay? And it also splits it up as far as the documentation, what a service animal is, what the emotional support animal is, things of that nature. And see, it is in a question and answer format.
So we're going to send everybody the PowerPoint of Nicki's presentation once we're done. Do you want me to attach this as well, this form you're going over?
I would, yeah.
Okay.
I want to make sure that everybody has a copy of it because it is very important and it just came out and there were so many questions in regards to emotional support animals that this is a really good tool to have. And this was published by by HUD. So it's very helpful and you can rely on this as far as, you know, what you should and should not do. So the new assistant animal notice will help housing providers in the process by offering a step-by-step, set of best practices for complying with the Act when assisting accommodation requests involving animals and information that a person may need to provide about his or her disability-related need for the requested accommodation, including supporting information from a healthcare professional. The legislation that was proposed back in 2019 failed. And we were very disappointed, and when I mean we, I'm talking all of the community association attorneys that practice in the state of Florida, because this is a hot topic and this is something that needs to be well-defined and translated for managers and board members. So the previous legislation does mirror the current legislation that is effective on July 1st. And these were the criteria for the failed legislation. Let me show you what actually did pass this year. So it's House Bill 209 and Senate Bill 1084, and this is effective July 1st of 2020. It amends the Florida Fair Housing Act by prohibiting discrimination in housing against individuals with a disability who require an ESA, prohibits housing providers from charging additional fees pertaining to an ESA. The individual requiring the ESA is liable for any damages to the premises or to any other person resulting from the ESA, like we had discussed previously, dog bites. Allows a housing provider to request supporting information regarding the individual's disability and disciplinary actions against a healthcare provider, practitioner license for providing documentation for an ESA. So all those guys that are online right now that are offering certificates for a flat rate are going to be out of business, hopefully. And then on top of that, there will be criminal liabilities for providing false and fraudulent documentation in support of an accommodation request for an ESA. Why on earth they did not approve this in 2019 is a mystery, because the legislation almost mirrored the 2019 legislative proposal and did not pass. But it did pass this year, and it actually was the first bill that was actually passed. So I'm happy that we're heading in the right direction as far as the laws are concerned to protecting the community associations, because I do think that there are a lot of individuals out there that are scamming the system, and we need to put a stop to it. And with that said, does anyone have any additional questions for me?
Okay, guys, I'm going to unmute everybody, and you may have to go in and each unmute yourself when you're ready to talk, but let's open it up to questions. I'm not going to put you on video because I don't like to be on video, and you may not either, unless you want to be.
I think I'm the only one on video, but I see a lot of muted buttons. So if anyone has a question, please unmute yourself. Well, with that being said, Carrie, I don't think we have any questions. Carrie, can you hear me? You're on mute.
I'm sorry. Yes, I'm just a talking. Yeah, is anybody having trouble speaking? Because it seems like there was a lot of questions, and then all of a sudden you guys got shy on us.
Hi, Nicki. This is Denise. Can you hear me?
Yes, I can. Hi, Denise. How are you?
Hi, good. I just had to call in because I don't have audio speakers on the PC I'm using. But we recently had a situation where the community I'm with has leasing restrictions, pretty strict. They also have pet restrictions, but the tenants that applied, the initial lease had one tenant with no pets indicated. Initially, two other adults were staying at the property, and it was said that they were there just to help the move-in process. but after 2 weeks, it was apparent that they were staying long term. So we asked the agent, the rental agent, to, get with the tenant and find out what the deal was with the pets that were not noted on the lease and the additional tenants. At that point, the board had already kind of decided to deny the lease based on misrepresentation of the facts not stated on the lease with regards to additional tenants and dogs. The initial feedback from the tenant to the rental agent was, like I stated, that they were there only temporarily, but then they did say, well, we'll go ahead and add one of the other adults with the 2 pets, and they said that they were service animals. So long story short, 28 days later, we were basically saying, no, it's still denied because they're not properly taking care of the animals, and things that were clearly violating the pet restrictions, in addition to the fact that they misrepresented the initial lease. So the question that I'm asking is, can the tenant claim discrimination for what they're saying are service animals, even though it lends us to believe they're not properly documented as service animals based on what was asked of the rental agent to obtain? They obviously aren't educated in how to even ask those questions. So the association wants to, make sure that they were in their rights to deny it based on misrepresentation and nothing really related to service animals. It's basically stating, the facts of the nature where they have 2 other people that weren't part of the lease and 2 dogs, and then they haven't been really even following the pet restrictions of how to properly care for the animals and, the leash and cleaning up after the animals and so forth.
Right. Okay. Let me ask you this. In your client's declaration, do they have a definition for occupants, tenants, guests? Because that's going to be that's going to determine whether or not this person needs to get approved by the board.
It's not as specific as when does it switch from someone who's there every day overnight for weeks at a time, short term, right? It's not as specific to define what is considered short term versus long term.
Okay. That's critical.
But due to so obviously there's a little bit of room for interpretation there as to how long do you let someone slide with 2 people not on the lease. And it was a red flag from the beginning because that person alone, the rent to income ratio was a flag on the credit report. And it was even noted to the rental agent that it's really more or less between the owner and the tenant as to whether they feel that that person is going to be able to, meet the monthly rent every month to pass mustard. And they,
let me answer that portion before we jump to another topic, because I never.
Oh, I think
to go after the assessments is the owner. So unless you have some sort of a lease addendum with the owner and the tenant that the association signed, or you have specific restrictions in the declaration that gives the association the power to evict those non-complying tenants or guests, you're going to be in a very difficult situation because you don't have the power to do much, because the declaration does not provide for those specific instances. So I would look first, and this goes for everyone. This is a good question. This is a very good question. You need to look at your governing documents to see whether or not you have a definition for the tenant, what a guest is, and a guest is someone who stays less than a week, okay, and they don't have to be approved by the association. Anybody that stays over a week, they need approval by the board. They need to submit the application and do everything that they're supposed to do, just like the regular homeowner. But if you don't have that in your declaration, you're going to be in a pickle, okay? Because that in and of itself is how the board would have the power to actually implement these restrictions against these animals. And it sounds like these guys really aren't legitimate disabled individuals, and that they just want to keep the dogs with them. Does your association have rules and regulations relating to the restrictions of animals, or the exceptions
Yes.
for an ESA, or they do?
Well, they don't have specific language in there right now about, like an ESA application, but there are, requirements that they have to specify on the lease, the type of dog, the weight of the dog, and how many animals, whether it's cats or dogs, because there's restrictions of how many cats and how many dogs per residence are allowed.
Okay.
So that was one of the reasons stated for misrepresentation, because after more than 2 weeks of, the 2 additional people and 2 dogs that weren't part of that original lease approved, we asked for an amendment to the lease, and they dragged their feet on providing it, along with the additional application fees required for running background screening on the other 2 tenants that weren't part of the original lease.
Yeah. This sounds like a DVPR petition for arbitration.
Mm-hmm.
Definitely.
Right.
I would send them a violation letter and let them know that they're in violation of the governing documents. And if in fact they have a service animal or an ESA, they need to provide documentation to that effect. But they are considered occupants now of the unit because they've been there for over a week.
Mm-hmm. Yeah, we did follow through with all that you suggested. I think the concern was, how do we know if somebody may be under FHA or ADA status in terms of what you ask them to provide to see if they try to go and claim FHA?
Well, again, remember, there's 2 differences as far as that's concerned, and the ADA is for service animals, but now this new amendment has extended to ESAs. So I wasn't sure if you got to see the HUD report that I popped up on the screen here by phone. Then,
yes.
Okay, I would read that because that just came out in January, and it will answer a lot of your questions in regards to whether or not, we can ask for this and ask for that.
Definitely. Thank you.
You're very welcome. But again, and this is for everybody on the phone, make sure you look at the declaration and the restrictions that it has on animals, and whether or not there are definitions for people that are staying at the property who need to have board approval. Okay, so normally we don't require board approval for anyone staying who's an immediate family member, but if you have a guest or a friend or a distant relative, I'm not talking immediate family, I'm talking cousins, aunts, uncles, things of that nature, and they're going to be staying at the unit, you have to have a definition in there for them, and if they don't meet the criteria of the definition, then they would be subjected to approval just like every other homeowner. It's where you draw that line as far as how long they're staying. Are there any other questions?
Well, I wanted to show you guys something, and it's sort of on a different note. I'm not trying to throw you a curveball, Nicki. Let me screen share this really quick. This is very interesting. Oh gosh, is it going to let me do it? Hang on. So this was on Facebook. Sorry, bear with me. Here it goes. Here we go. Here we go. So this was on Facebook, and apparently there really is a group out there called the Freedom to Breathe Association.
Idiots.
Well,
boy, this is out of left field.
Right? So I thought everybody might want to see this, because has anybody run into this yet? When I first saw it, I thought it was a joke.
That's funny.
So anyway, yeah, that's something to that's a whole nother topic, but I just
Wow.
wanted
So that's a great point to ask this question is if somebody tries to come in and claim ADA or some association that they're issuing a card to come into a public clubhouse, for residents, let's say, do we have to do anything with that and say, nope, our rules are our rules?
And let me just also say this about the American Disabilities Act, that there are lawyers out there that only deal with suing organizations for violations of the ADA. So be very mindful of that. They're just waiting around the corner for you to slip up so that they can file a federal lawsuit against the association.
Well, remember when those attorneys were going around trying to get everybody on the parking lot ADA violations a while back? Are they still doing that?
Yes, but not to the extreme that it was before. I think everybody got smart and changed the way that things were done. Are there any
Okay.
other questions? Well, it's 12:31, Carrie, so if you want, go ahead and close the meeting out.
I will be
Thank you
sending it.
again, everyone.
We'll be sending everybody an email to fill out the course evaluation electronically, so please make sure you do that. And we have a chat. And you're going to receive an email shortly after this class. So be on the lookout for that. It'll also have Nicki's contact information and a copy of the PowerPoint. And if I can get it between now and then, it'll also have a copy of that HUD form as well. You can always email me if you have any questions or want to reach out to Nicki. And you can also go to our website at www.bmitampa.org for additional resources. And with that being said, thank you very much for attending today, everyone.
Thank you.
Thank
you
you.
so much,
It was
Nicki.
good.
Thank you. Y'all have a wonderful day.
You too. Appreciate it.